Hello, everyone. Welcome to the webinar today. So glad that you could join us. We have so many new California laws to go over. So before we get into all of that, we're going to start with just a few announcements and introductions. Again, welcome. Thank you so much for being here. My name is Alexandra Alvarado. I'm the Director of Marketing and Education here at the American Apartment Owners Association. And today we have with us a few different experts in different fields that address here the California landscape, legal landscape. We have first and foremost here Anthony, Tony, as he goes by, Tony Burton. He's the founder and managing partner at AWB Law PC. He's spent his career litigating and fighting on behalf of his clients, whether their needs arise from an injury, a real estate dispute, or business dispute. I know that applies to many of you here on the call, and he works with his clients pretty closely to really employ the appropriate legal strategy and develop a plan. And he is admitted to practice in all courts in the state of California. So if you own rental property in California, Anthony is your guy. He's going to go over a lot of the new laws that we're seeing in California that took effect this year. And then after that, we're going to have with us Gregory Carlos. Greg, he's been with us before, the VP of Sales and Operations at DrBalcony. He's a UC Riverside graduate and a distinguished representative of DrBalcony. He's played a pivotal role in enhancing awareness about the balcony laws, which I'm sure many of you have heard by now is SB326 and SB721 ordinances. And he's also worked on improving those engineering inspections, making it a lot easier for landlords like you to comply. And lastly, we have Tolgar Alpagut, who is the marketing strategist for Deposit Proof, another really great tool to use to comply with California's new security deposit laws. So he'll go over that at the very end. And of course, we'll stop along the way for some Q&A. So if you do have questions, please put your questions in the Q&A box, not the chat. That Q&A box is the place where you should be putting your questions so we don't miss them. We're going to pick the top ones that we can. I know we're going to get so many questions and we'll be answering all of them offline. But for the ones that we can get to, we're going to try to prioritize those that are in that Q&A box. The chat, if you want to just leave a comment in the chat and say hi or where you're coming from, that's great. And I also want to get to know you all a little better. So we have a couple of questions to kind of launch this off. We'd love to know how many properties you currently own or manage. Is it just one or two, or even 50 or more? We usually get a mix. I'm always curious to see how this poll question turns out. We want to make sure that we're addressing here the different, laws as they apply to landlords that might have a certain number of units. And it looks like a lot of you are participating. We have over half of you that have put in your answers. So I'll go ahead and end the poll and share those results with all of you. Looks like most of you are in that 3 to 10 range, and then 1 to 2. And then 13% 10 to 50, 15% 50 or more. And a few of you don't own or manage any properties. So maybe you're just here because you're thinking of owning or managing properties in California. Very smart to do in a state like this. So I hope you stick around as well for the whole thing. And also, the next question, we'd love to know what best describes you. Are you a property owner, a property manager, a realtor, an HOA board member? And Jill is asking, so is this not only HOA related? No, it's not, but there will be some talk here about how, especially the balcony laws will apply to HOAs. So stick around for that. We will be covering some things for HOA. And I do see that we have a few HOA board members, not just you, Jill. Looks like we have actually a few that are joining in. And Sherry Schreiber from Compass One Paseo office. Hi, Sherry, welcome. She's in the chat. Go ahead and end the poll here, and we'll see here, no surprise, most of you are property owners, 42%, 33% the managers. We have some realtors, which is excellent, so you can advise your clients on these laws, 20%, and then 3% on the HOA board member, and one tenant. So love to see that. I'll go ahead and stop sharing here. And now that we've sort of settled in, I'm going to pass this off to our first presenter of the day, who is Tony Burton. So Tony, if you could share your screen, we'll get started with your presentation and jump right in.
Sounds good. Thank you so much, Alexandra. All right, you can go ahead. Alex, can you see my screen okay?
Yes, there it is. Looks great.
All right, just want to make sure. All right. Well, thank you again for the introduction, Alex, and Greg. I'm also a fellow UCR alumni, so it's good to know. So I wanted to talk about a few key laws that have changed in California in the early to middle part of this year. So a little bit of information about our firm. We do handle commercial, residential, landlord, tenant matters. We've been doing so for 10 years. We cover most of the major Southern California areas, and we do have some other areas of practice as well. Just want to provide a little legal disclaimer. So we are not providing any legal advice to anyone or forming any attorney-client relationship. This is for informational purposes only. If anybody does have any specific questions that maybe apply to a specific situation, I generally ask that those questions be asked not in front of the group. Generally don't want attorney-client information being shared in a public setting, and oftentimes people don't know or aren't aware of when that protection would apply or not. So if there's a very specific situation or scenario, normally that's a little better to be asked in a private setting. But again, if it's a more of a general question, I'll be happy to answer that today. So the first one I wanted to cover is AB 2493. This discusses applicant screening fees, and many property owners are already aware of the fact that applicant screening fees could be charged, but this changes the current laws on the amount of fees that can be applied and in circumstances when those fees would need to be returned. So the law has changed such that screening fees cannot be charged unless there actually is an available unit or one would be available within a reasonable period of time. There's no bright line rule as to what a reasonable time frame is, but if a unit is going to be coming available in the next, I would say 2 to 3 months or less, that would likely be considered to be a reasonable time frame, and that would be an appropriate circumstance where a screening fee could be charged. So if a landlord wants to charge a screening fee, they now have two options. So they can process applications and take the first come and first qualified applicants. They do have to provide written criteria with their rental application and notify the applicants that this is going to be a first come, first qualified screening process. The other alternative is that what the landlord can do is they can return the fees to applicants who are not selected for tenancy. It doesn't matter what the reason is, but if you're not taking first come, first qualified, this is the other option that you can use. As far as the time frame goes as to when those would need to be returned, it is the lesser of 7 days after the qualified applicant is selected or 30 days from when the application was submitted. So the law is also amended to require that applicants be given a copy of the consumer credit report that is obtained as part of the application screening process. The requirement is automatic. The tenant does not have to ask for it. If the tenant does request it, however, it does shorten the time frame from 7 days to 3 days as to when that needs to be provided to them. And the landlords are given an option to send this by personal delivery mail or electronic mail. Another update that we've had this year, and it was phased in 2 different parts, was an update on how landlords are required to handle and document security deposit deductions. Now, oftentimes when legal changes come into effect, it's usually seen as more cumbersome and the state generally just throwing more obligations and more red tape on property owners. But this one I actually thought was a beneficial one because I do assist clients who get sued for security deposit disputes all the time. Now, normally it's in small claims, but sometimes there are more significant disputes that also get brought into it. Following these guidelines is actually going to be a very helpful way to prevent property owners from being sued, or even if they do get sued, from being found liable for taking a security deposit wrongfully, because if a tenant is able to show that a deduction was made in bad faith by a landlord, not only can they recover their deposit or the deposit amount that was kept in bad faith, but they can get up to 2 times that amount as a penalty against the landlord. So some of the financial downside on that can be pretty stiff. So starting in April, the landlords were required to take photos of the rental unit after possession was returned and before repairs and cleaning. This is, like I said, very beneficial to the landlord, because this actually creates a documented, irrefutable record of what the condition of the property was in when possession was returned to the landlord. And in these types of disputes, photos and videos usually will tell the story better than any kind of written description or written claim will. So I always suggest to my clients that they take video and photos in the event that the photos don't show the condition as clearly as a video might. So walking through the unit with video, and then of course taking photos of specific areas, is going to be very helpful. There is also a requirement to take photos of the unit after repairs and cleaning have occurred. Again, this gives a judge or someone else who's looking at this record, who has no involvement and hasn't been there, a clear record where they can compare side by side. This is what it looked like when they got it back. Here's what it looked like after repairs. And those photos really will end up telling the story more than anything else. Now, as of July 1st, photos have to be taken immediately before or when the tenancy begins. Oftentimes, property owners will walk through the unit with the tenant at the inception of their tenancy, so that any potential issues with the unit can be identified. This is an ideal time to do that. Of course, it can also be done by the landlord on their own as well. But this is required so that the condition of the unit at the time of movement can be proven, and so that there's a documented record of it. The photographs that have to be produced after the unit is vacated and after cleaning and repairs are completed have to be given to the tenant with the security deposit itemization. And as most property owners know, that has to be provided within 21 days of the date that the tenant vacates. The delivery method for the photos is actually different than the itemization, in that the legislature is allowing landlords to produce this by mail, email, with a link to the tenant or the flash drive, which is helpful because some of these photos are very large data sets, and printing out a substantial amount of photos can be cumbersome. So you do have an alternate method of delivering those photos if the landlord chooses. This is a list of the itemization requirements that a landlord is also required to follow. Any costs that are incurred require a written explanation. A copy of an invoice or an estimate has always been required and is still required, and it does have to have the name, address, and phone number of the vendor who is being hired to complete those repairs, or who prepared the estimate or invoice. Photos have to be included with the explanation. Again, these can be the same photos that the landlord is required to take at the time of move in or move out. Some kind of explanation or picture should be included with every single deduction. The intent behind the change in this law was to prevent deposits being used to subsidize improvements to the property. And of course, I do see allegations made in these kind of disputes that that's exactly what the deposit was used for. So I did provide a little note here, and this is really kind of piggybacking on what I described a moment ago, that if you follow these guidelines, it will end up helping prevent future legal disputes or future liabilities from arising because of a landlord applying a deposit in a manner that they're legally entitled to, but where the tenant is disputing whether or not it was appropriate. There is also a new law in place that any fees that are incurred by a landlord for posting or serving a legal notice cannot be charged to the tenants. And if tenants choose to pay by check, there cannot be a charge associated with that as well. So they need to be given that as an authorized method to pay their rent. And finally, there is now a mandatory offer of credit reporting that has to be given to tenants so that positive rental payment history can be recorded on their credits. It has to be provided at least signing as of April 1st of this year. And then if there's any existing tenancies that this would apply to, that has to be provided on or before April 1st of 2025. There are exceptions, though, and this is really meant for landlords who operate on a much smaller scale, because the requirements, it can be somewhat complicating and a little cumbersome. So if a landlord has 15 or fewer rental units in total, so this could be apartments, houses, any combination of them, they do not have to provide this, but that is unless the landlord owns more than one rental building and they are one of these, they meet one of these three criteria. So a REIT is a real estate investment trust, or if they're a corporation or an LLC that has a corporate member in it. So if they meet both of those criteria, even if they do have 15 or fewer rental units, they would have to offer mandatory positive credit reporting to the tenant. The offer to the tenant has to contain certain information. So letting them know it's optional, identify which bureau it's going to be reported to, any fees that are incurred, instructions on how to opt out if the tenant doesn't want to opt into it anymore. And the tenant has to be given a chance to sign the offer, and that should be going in the tenant's file. The offer to them can be delivered by email or mail. And it has to have a self-addressed envelope so the tenant can send the signed offer back to the landlord if they choose to elect to have the credit reporting. So the landlord can recover the actual cost of reporting are $10, whichever is less. The tenant can opt out, but they're prohibited from opting back in within 6 months. That is also true if the tenant fails to pay the fees for their credit reporting for more than 30 days, and the landlord chooses to terminate their right to having reporting. If they fail to make that payment, though, it can't be deducted from their deposits. You can't use rent to cover it, and they cannot be evicted for that. The only option for the landlord is to terminate the reporting if the failure to pay goes on for more than 30 days. So I know I had a limited amount of time, and I hopefully haven't taken more than it was allotted to me. So I want to thank everyone for their time today. This is some information for my office, and to the extent anybody doesn't get it, I'm sure that information can be provided later in case anybody has any follow-up questions.
Wonderful. Thank you so much for that. We do have plenty of questions coming in, so stay tuned. This is part one of the presentation, so stay even if you don't have questions, people. We have more to cover. So Judith is asking, do photos need to be sent if no deductions are charged?
So yeah, so it actually there is nothing that is stated in the law that says that a landlord's alleviated of that obligation. So it requires the landlord to document the condition no matter what, and to provide those photos. So yes, that should still be provided to the tenant, even if there's no deductions that are made. And like I said, there's multiple methods by which a landlord can actually provide those. Right. And make sure you keep those in your file for future tenancies in case there's any dispute about who caused what damage. So.
Good advice. Kevin is asking for AB 2747, the rent reporting law. Is the above 15 units only count California properties, or do they count rentals in other states?
That's a good question. The law actually doesn't say and doesn't differentiate on that. My presumption would be that it would likely apply only to rental properties in the state of California. I would probably have to go through the legislative history to see if they gave us an answer to that. I'd venture to guess they probably didn't, though, because the legislature, it generally makes these things about as clear as mud. So.
That's a good way to put it. And that's why we have you on. Another question that came in is also how to establish the date and time of photos at move-in or at move-out or move-in. Any advice there?
So with most smartphones and cameras, if you're going to use a digital camera, they usually will actually have metadata attached to the photo that will actually tell you when the photograph was created. My suggestion would be take all the photos you take and put them in a file folder and label that folder based on the date that the photographs were taken. In case any of that metadata gets lost, you at least have something that you can follow that confirms when those photographs were taken. But like I said, the photos themselves should have some data information on them.
Great. Beatrice asking, if a tenant has submitted checks in the past that did not clear, can you require some bank checks or other method of payment?
So you can charge a fee if a tenant does make a payment with and the check is not honored and it's NSF. So that's perfectly appropriate. There just can't be other associated charges just by virtue of the fact they are electing to pay using a check.
Great. Genesis saying, for the delivering photos, is uploading them to their resident portal sufficient?
So it didn't in the law. That's not actually written as a way to share the photographs. Now, if the resident portal has some kind of link where they can access them, that would be appropriate. Most of the time, people have them saved on some sort of server like Google Drive, Dropbox, or somewhere else. Most of these portals, the tenants are denied access to them once they've moved out. So that would probably be a less than ideal way of sharing the photos with them, unless, of course, the portal is, if unless they have unfettered access to it after they move out. I'd suggest another method of delivery.
Well, great, because we'll probably be covering that later in the security deposit proof segment. One last question before we let you go. For Meyer, if the property has maintenance employees turn apartments, is there a standard for how much the property charges for turn costs for cleaning, carpet cleaning, painting?
No, so there's no hard and fast standard. California goes by on the basis of a reasonableness standard. So, cleaning and those associated fees are one of the things that are outlined in the civil code that says you can charge those. But again, there needs to be some reasonableness to it, and the benefit of having all the photographs you can show. This place is filthy. Like we're not overcharging for cleaning. It actually required a deep clean versus just our standard cleaning. So again, just as long as you've got something to support it, and again, the fees are, like I said, within reason, that you should have no issue.
Wonderful. Tony, if you could put your contact information in the chat before you head out. A few people were requesting that. Again, we're going to be emailing everyone the information here from the webinar. I'll include Tony's information in the follow-up email just in case you can't grab it. We'll stop there for questions. Any questions that are unanswered, we'll be sure to follow up with after the webinar. We're going to start our next segment. Thank you, Tony, so much for talking to our group. And if you can come back for questions, that'd be great. If you can, no worries there.
No worries. I'll stay on for a bit, and then if I can, then I'll definitely stay for some more.
Yeah, feel free to type some answers to people's questions in the Q&A if you'd like. Okay, wonderful. So next up we have with us Greg Carlos. I'm going to ask you to come up on the stage, the virtual stage, and talk to the group. We would also like to ask you all a new poll question, which is, have you already conducted your balcony inspection? So go ahead and give us your yes, currently in progress, or no, not yet. We know that the deadline for HOAs is a little different, right? We're going to talk about that, but hopefully you all have either started it or are in progress already. It looks like actually it's pretty split here on the call today, Greg. It looks like well, I'll show the results here. We'll finish the poll here. So it looks like we have 40% say yes, they've done it. 10% say currently in progress, and 50% no, not yet. So Greg is going to cover everything you need to know about these new balcony inspection laws. Another quick poll question before we give it off to Greg. Also curious if you have any exterior elevated elements, such as balconies, decks, stairways, or walkways. How many do you have? Is it 1 to 10 or 11 or more of these exterior elevated elements? Or maybe you don't know. And if you don't know, that's okay, because part of the reason we're doing this webinar is so that you can see whether or not you even need to worry about this law. And of course, DrBalcony would be able to tell you pretty quickly if you do need to, or if you do have those exterior elevated elements. So I'm going to go ahead and end the poll, and we will share the results here. So it looks like 39% are in the 1 to 10, and then 30%, 11 or more. A few of you don't know, and 27% do not think that they have any exterior elevated elements. So With that information, I'll hand it off to Greg to get started on the second part of our presentation today. Thanks, Greg.
Of course, thank you so much, Alexandra, and thank you as well to Mr. Tony Burton for sharing his knowledge and expertise with us. Always a pleasure to listen to him, and you know, uh, really appreciate him for being here today. With that being said, guys, let's get started on the California balcony inspection laws. So, quick little disclaimer here. Before we get started, I'd just like to point out I'm not an attorney by any means, and by participating in this webinar, you acknowledge and agree that we are not responsible for any decisions or outcomes that you make or that may result from the information shared. Now, we are the leaders in this balcony inspection industry, so we do believe that the information that we provide you is hopefully going to be helpful and beneficial so that you can comply with these ordinances. And just a little background on us, who is Dr. Balcony? So we are the one-stop shop for all of your balcony inspection needs. We have helped over 5,000 properties throughout California achieve compliance with the SB721 and the SB326 ordinances. We have a best price guarantee where we're really confident in our pricing. But if for any reason you do find a better price out there in the market, we will always beat that by 20%. Doesn't happen too often where people find lower pricing, but that is available as well. So you always have confidence to shop with Dr. Balcony. Additionally, we are architects and engineers. We are not contractors, so you have no conflict of interest with us. And that's something else that our clients really, really enjoy and like. So, why these balcony inspection laws are important? It's really important to understand the SB721 and SB326 requirements so that you're able to stay fully compliant with any upcoming deadlines. That 2025 deadline is coming up. Additionally, you want to protect your residents, right? This is about safety. So, protecting all residents, tenants, loved ones, and as well as making sure that you're protecting your uh, liability. So, hopefully, this information that we share is going to help you all. How big of a concern are these inspections and are exterior elevated element related injuries? So annually, there are over 6,000 injuries that occur annually from exterior elevated element related incidents. There is a 21% increase in balcony and deck failures annually as well, over 550 trauma center admissions annually, and tragically, there are 140 children's deaths that occur annually from exterior elevated element related incidents. Additionally, there is a report by the California State Senate Committee on Housing that says that more than 90% of balcony failures in the last 20 years involved wood deterioration that went undetected until failure occurred. So that's what we're trying to look for in these inspections. That's what they focus on. We're mainly looking for wood rot and a couple of other defects that may provide, structural deficiencies. So hopefully we're able to catch those and prevent these accidents from happening in the future. Now we do have a video for you. Let's see here. Alexandra, can you let me know if you can hear the sound?
No, you'll need to stop your share and start your share over again and select the option to allow sound to share.
Got it. Let's see. Let me try this real quick.
Should be on the right-hand side, like a little checkbox you can select there.
Perfect.
There you go.
All right. And just keep in mind, everyone, these are only incidents that have been captured on video. Majority of these are in California, but there's so many of these that we are not aware of, that we never see, that were never captured on video. So, um, you know,
Still can't quite hear the sound, but it's okay.
All right, let's see. All right, so two incidents that we saw in that video that I really want to talk about. Obviously, those were all really scary, scenes that we saw there, and we want to avoid any of those accidents from happening again. First, that 2015 Berkeley balcony collapse. That's the reason that these laws started in the first place. So tragically, in 2015, there was 13 young adults on a balcony. That balcony suddenly collapsed, and these young adults plummeted 40 feet to the ground. Six of these young adults were killed, and the other seven were severely injured. What was most shocking is that after an investigation occurred into what caused this collapse, they found that it was due to dry rot. And the really shocking part is that the building's only 9 years old at the time, right? So to put that into context, that's a building built in 2016, right? Which today, which is I believe the majority of us here would consider that a relatively new building. So it goes to show that not just, these old properties that were built in the 70s or 80s are going to be failing these inspections or at risk of a potential incident or accident from occurring, but newer buildings as well. And something that I hear a lot is, hey, well, why were 13 young adults on a small balcony, right? Well, my rebuttal to that is that 2025 Silver Lake balcony collapse, where you have this huge third floor balcony where four people and a dog were, on that balcony, and it suddenly collapsed as well. And this balcony had a much higher load bearing capacity than just four people and a dog. Thankfully, there was a second floor balcony that caught this fall and uh, was able to prevent a tragedy from occurring. There was only one broken arm, but these incidents are happening all around us, right? And we always think, hey, it's not going to happen to me until it does. So this is what we're trying to avoid. Now, there are two laws. There's the SB721 and the SB326. The SB721 applies to multifamily apartments with three or more units. The deadline was originally December 31st, 2024, but it was extended 1 year to December 31st, 2025, which is about 3, 4 months from now. So that deadline is coming up. Additionally, for these inspections, you have to have 15% of each type of exterior elevated element inspected. So if you have 100 balconies, 100 walkways, 100 stairways, you have to have 15 balconies, 15 walkways, 15 stairways inspected. These inspections must occur every 6 years, and the people that can do these inspections are structural engineers, architects, general contractors with a B1 license, certified home inspectors with specific licensing as well. The SB326, on the other hand, applies to condominiums and HOAs with three or more units. And this deadline was not extended, right? That's something that I really want to emphasize because this deadline was not extended. And a lot of people believe that it was also extended with the SB721. But if you have not done your inspection on your HOA or your condominium, you're out of compliance right now, and you're likely already facing some of those consequences. So that may be why you're here today. But make sure you have that inspection done as soon as possible. You want to comply with the ordinances as quickly as possible and prevent any future consequences from occurring. Now, the SB326, you do have to have a 95% confidence rate in the a 95% confidence in the findings. So typically all exterior elevated elements are going to be inspected. And these inspections, since they are a lot more thorough, they have to occur every 9 years as opposed to every 6 years for the SB721. The only people that can do these inspections are going to be structural engineers and architects. Now, a lot of people know these as the balcony inspection laws, but they do not just apply to balconies. They apply to walkways, decks, porches, stairs, anything that's 6 feet above the ground, has a walking surface meant to be walked on, relies partially or wholly on wood for support or structural stability, and additionally must be on the exterior, so it has to be exposed to the natural elements such as, the sun, wind, water, rain, things like that, right? So uh, we have an example here where on the very left-hand side, you're going to see cantilevered balconies. Now, these balconies, everyone's in agreement. They need an inspection. They're sticking out from the building. They meet all qualifications. No one's confused about these. Now, On the very right-hand side of this photo, you're going to have balconies that are kind of tucked into that building, right? They're not sticking out from that building. Uh, a lot of people are going to uh, assume that these do not need inspection, but they meet all qualifications of an exterior elevated element. They're 6 feet above the ground, have a walking surface meant to be walked on, and rely partially or wholly on wood for structural stability or support, and they're exposed to the natural elements as well. So something like this does need an inspection. Make sure that if you have those balconies or those walkways that are tucked into the building, you have those inspected as well. Now in the middle, you're going to have Juliet balconies. They don't have a walking surface. They're not meant to be walked on. Something like this is going to be exempt from inspection. Couple of more examples of exterior elevated elements. So in the very left-hand side, we're going to have something called an exposed exterior elevated element. So you can see all the wooden components yourself, right? You can see the joist under the landing of the little stairway and the landing. So something like this is going to be purely a visual inspection. There may be a moisture meter involved as well, but this is usually very quick, very easy. Typically, if there's rotting here, you're going to be able to see it yourself as well. Now, in the middle, you're going to have a traditional enclosed exterior elevator element where, on the top, it's going to be concrete or some sort of um, some sort of concrete on the top, but on the bottom, there's going to be stucco. Now, even though you're not able to see any wood inside of that stucco, there's going to be wood, right? The entire structural element is made of wood. So what we're going to do is we're going to drill small holes about the size of a nickel. We're going to insert a boroscope camera. We're going to take detailed images of what the condition of that wood is, and those images are going to be presented to you in your report as well. So if you have stucco, you're typically going to have wood. Now, on the very right-hand side, you're going to have a stairway and walkway that is completely concrete, completely metal. Something like this does not need to have an inspection done. It is going to be exempt from inspection just because there is no wood involved. So if you do not have any wood at all and you're completely metal, completely concrete, you're going to be exempt from inspections. Now, some warning signs that may show you, hey, I need to have this inspection sooner rather than later, or maybe, hey, I'm likely going to fail my inspection. Any large cracks, rot, rust, unstable railings, signs of water intrusion in the stucco or on the surface, so water staining. Additionally, properties closer to large bodies of water, the closer you are to the ocean, the higher the condensation is going to be in the atmosphere, and that's eventually going to cause a bit of wear and tear on your balcony. Additionally, we found that people that have, a lot of plants on their balconies and they're constantly watering them, that constant weight and pressure, additionally, that can eventually cause small cracks. The watering of those plants can eventually seep into the balconies, and we found that those balconies have a higher rate of failure as well. Now, I really like this example here because this is an inspection that we did where the owner had 20 balconies. They all looked in tip-top shape when we went out there. Uh, from the exterior, you could see that, there was no warning signs actually. Everything looked great. Turns out this owner had been painting the balconies pretty regularly, but not with the proper sealant. No sort of waterproofing was involved. And the owner himself said, hey, look, they look great, but I'm concerned about what's going on inside of the balcony. There's a lot of sagging, there's some dead spots. Of course, we did the inspection visually at first, but then we also did a boroscope method. And once we drilled inside of that balcony, as you can see in the second photo, everything was completely rotted, right? And we're really happy and thankful that we were able to catch this on time before someone was hurt. These balconies were all in similar condition where everything was completely rotted, and it was really unsafe for anyone to use any of these balconies. Now, thankfully, we were able to also help the client with the permitting application, where we're going to draw plans and submit these plans to the city. We specialize in making this project as simple and cost effective for you as possible, since we have no conflict of interest during the construction side. We're not contractors, once again. We're only architects and engineers. So what we do is that during that permitting process, we're going to show how these balconies are going to be repaired. The city is going to approve them. Once they're approved, then at that point, your contractor is going to do the work. Now, with our permitting process, instead of completely redoing this entire balcony, what we did is something called joist string. So joist string is shown on the third photo, where you're still going to be able to see that rotted wood joist, but there's actually another piece of wood that is newer, that is in better condition, and that's attached to that old piece of wood, right? And That's going to provide additional support, additional stability. City's going to approve that as well. It's a very common method, and but just by doing this, instead of redoing the entire balcony, you're able to save the owner tens of thousands of dollars. Now, let's recap the typical inspection process, right? So you're going to call a company such as DrBalcony, and we're going to give you a proposal for your inspections. We give proposals for free. The inspections are not free, but the proposal is free. And in that proposal, we're going to determine a base number of exterior elevated elements that must be inspected. If the exterior elevated element is open, as seen in that first photo, it's once again going to be mainly a visual inspection, perhaps a bit of a moisture meter test. If the exterior elevated element is covered, traditionally it's going to be by stucco. Then at that point, we're going to use our patented inspection method where we're going to drill small holes about the size of a nickel, about 2 to 3 inches deep into that stucco, so we can get our boroscope camera in there. We're going to take detailed images of what's going on inside of that balcony, walkway, whatever it may be, and those images are going to be presented to you in your report as well. Now, the inspection report actually has to include photos, right? So, a company, whoever you choose, hopefully it's us, right? Uh, has to show you proof of whatever they find. They cannot just say, hey, there's rotting on your balcony. No, they have to give you photographs in that report that's going to show that rotting as well. They have to identify all exterior elevated elements. They have to give you a clear statement on the physical condition, whether it passes, whether it's a failure, whether it's a non-emergency failure or an emergency failure, notes on expected future performance, how long they think this balcony or exterior elevated element will be okay to use, maintenance recommendations as well, and it has to be stamped or signed by the inspector who does this inspection. In our case, a licensed uh, professional engineer or architect, right? So that's the most important part because uh, all of these requirements are mentioned on the law, but the last part, which is the stamp or the signature of the person that doing the inspection, that's what gives them the liability, right? And that's what makes it a valid report. So make sure that you have that. Uh, Now, what happens after the report itself, right? What happens if you pass or fail? So first, if you pass, you're okay. You're good for the next 6 years for apartments, for the next 9 years um, for condominiums and HOAs. And you have to keep these reports in your record for 2 cycles, which is going to be 12 years for apartments and 18 years for HOAs. And now cities are typically going to start asking for these inspections next year. Some cities are going to ask for them through insurances. Other people are going to do them in other ways, right? But you're not going to need any sort of work if you pass. Now, if you have a non-emergency failure, which is the most common type of failure, it means, hey, maybe there was some rotting, but it's not enough for it to be an immediate concern. Now, the report has to be delivered to you by the owner, uh, or by the inspector within 45 days of the inspection. After that, you have 120 days to apply for any necessary permits. Once those permits are approved, typically cities are taking 1 to 2 months to approve any permits at the time because everyone is applying for permits at this time to repair their exterior elevated elements. Once those permits are approved, you have another 120 days to do the actual work, and there is a chance that the city could give you another extension or two of 30 to 60 days. So from the day you have your inspection done, unless you have an emergency failure, you're gonna have uh typically about a year to do that actual work, right? A year timeline. So you do have quite some time. Now, if you have an emergency failure, as mentioned, the inspector has to give you the report within 15 days. Additionally, this report must be sent to the city immediately, and immediate preventative measures must be taken for repair, right? Sometimes that's going to be closing off a balcony so no one goes on the balcony. Sometimes that's going to be temporary shoring, which is going to provide additional support for a walkway or stairway, right? It's a case by case thing, but there are some immediate things that are going to need to be done. After that, you should apply for any necessary permits within 30 days. And then once those permits are approved, you should commence the work immediately. Now, emergency failures are a lot less common. Typically, if you have an emergency failure, you're already going to know you're going to have an emergency failure, as those are causing an immediate threat. Now, as mentioned, once you do your inspection, there is a second step, which is the permit application process. A lot of people try to skip this step, and I highly recommend against that. The law clearly states all necessary permits for repair or replacement shall be obtained from your local jurisdiction. So typically depending on the actual defect that you may have, but if there is something structurally wrong with your exterior elevated element, a licensed architect or engineer may have to create plans that you're going to submit to the city that are going to show how these exterior elevated elements can be done, or can be repaired. So once you submit those plans to the city, it's going to be a little bit of a back and forth, and at the end, they're going to approve those plans. Once those plans are approved, then you can hire a contractor that best fits your needs, and they can pull this permit from the city and just follow the step by step on how to do the actual work. Now, sometimes your contractors are going to have someone that can do these plans and permits for you. DrBalcony does offer the second step, which is going to be this step as well. A lot of people like staying with us just because we do specialize in making this as simple of a process as possible. But once again, make sure that you do all three of these steps, because skipping any of these steps can result in any of these consequences, right? People that did not do their inspections on their HOAs are facing a lot of consequences right now, and people that have apartments can learn from them right now. They're unable to refinance their property. They're unable to sell their property. Insurances are dropping them. They're facing fines of I haven't seen the $500 per day, but I have seen $100 to $200 per day for people that are over the deadline. And then I have seen that people that try to do these repairs without permits, they have to restart the entire process as well. Now, as we were mentioning, get that inspection done sooner rather than later, right? Budgeting purposes. If you have a non-emergency condition, you're gonna have nearly a year to do those actual repairs, right? And if you do have an emergency condition, then uh, you know that's even more of a reason that you should do that now, right? You want to protect your liability. You want to make sure that everyone's as safe as possible. These inspections may be a couple of $100s, right? Maybe a couple $1,000s, depending on your property size. But the cost of a lawsuit is a million times more, right? I mean, look at the Berkeley balcony collapse. Obviously, you cannot put a price on these precious lives that were lost, but it ended up costing the owners over $20 million in a settlement. There's some different statistics here. The one that I really like to focus on is that Chicago incident in 2011, where thankfully no one passed away, but it still ended up being nearly $5 million settlement. So obviously these inspections are, they're not free, but it's going to save you a lot of money in the long term. Now, some tools that I'd like to point out that we're going to send to everyone with our presentation. These slides will be going out on Monday, I believe. We'll send these out to everyone. If you click on the checklist here, you're going to be able to see a balcony inspection checklist, how to prepare for your inspection, what we're going to be looking at, how to make sure that you pass as well. We also have another tool that's going to be Balcony Inspector Checklist, right? Same thing here. You're able to click view checklist, and a little pop-up of a PDF is going to jump out to you. It's going to tell you how to make sure that your inspector has the correct licensing, how to make sure that there's no hidden fees, how to make sure that they're going to do a good job, maybe how to verify their previous work, right? So, really cool tools that we have here. And then finally, a sample inspection checklist, right? Or a sample inspection report. So, you'll be able to see a DrBalcony report, see what you can expect during this inspection, right? It'll give you the table of contents. It'll tell you how many exterior elevated elements you may have. Did they pass? Did they fail? It'll give you a nice little summary for each exterior elevated element, the general images, and then at the end, you'll be able to see the images that have defects as well. So some really cool tools there for everyone to use, and hopefully this is going to help you out. Now, one of the last things that I'd like to speak about is single family homes and duplexes. We do have, every time that we do these webinars, a lot of people reach out to us about single family homes or duplexes, saying, hey, look, I know that this law is only for 3 or more units, but maybe I'm concerned about my own home or a duplex that I may have. The risks are still there, right? And, obviously, if it's your own family, even the more reason to get this inspection done. And if you have a duplex, right, you're still able to face the same amount of liability, if an incident does happen. So by all means, yeah, give us a call and we'd be happy to help with any single family homes or duplexes as well. And the last thing that I'll leave you all on is once again, just a little summary of why choose DrBalcony. We have a 3-step quality control process where we're going to have our field operators submit the results to our engineering team. Our senior engineer, our senior architect are all going to look at your report before it goes out to you. We've completed over 5,000 inspections throughout California. We service all of California from San Diego to Redding. We have the fastest scheduling with we can get out there tomorrow if you need it, or you can start booking your date for October or November. Quickest report turnaround time about 3 days to a little over a week for larger reports. We're powered by AI, so we make sure that we don't miss anything. We only do the inspections. We don't do the repairs, so you have no conflict of interest with us. And once again, we do have that 20% price beat guarantee. And with that being said, I believe we have a poll question here. Also, we do lunch and learns for individual property managers, right? If you'd like us to, if you found this information useful and you'd like us to go out to your office, maybe bring some lunch for your team and tell everyone about this. Answer your questions in person. Feel free to let us know, and of course, these lunch and learns are free. So. Yeah, thank you.
Wonderful. Love a lunch and learn. So yes, if you want to get contacted by Dr. Beckley, say yes in the poll, leave it up for a little while. We're going to go on to the next part of our presentation here, which is deposit proof, which we have Tolgar here. As Tony mentioned, the attorney at the beginning, we have some new security deposit laws in California. And so deposit proof is one of the ways that you can comply with that a lot easier. So I'll let Tolgar explain a little bit more about how it works, and then we'll open it up for questions. And by the way, please put your questions in the Q&A box, not the chat. We're going to prioritize those and try to get to as many as we can. Thank you, Tolgar.
All right. Thank you very much, Alexandra. I know that we're at the end of the hour, so I'm going to try to make effective use of the time here. As Alexandra mentioned, Tony already kind of touched up a little bit on California Assembly Bill 2801. I'm just going to dive a little bit deeper in there and then present a solution for the team here. So effective April 1st, 2801 introduced important changes to how residential property managers and landlords handle the disposition of their security deposits, and that includes the move-in and move-out inspections and tenant communication. And the purpose of the law was really to kind of prioritize fairness and documentation to set new standards for transparency and compliance for all the parties involved. And as Tony had mentioned, there is a photo-based documentation portion of it where at multiple points in the lease cycle. So As you can see on the slide there, there's two dates. There's April 1st as well as July 1st of this year. Let's call April 1st phase one, and that was really designated towards the move out portion where landlords have to photograph the property immediately after their tenant vacates, and that has to happen before any repairs or cleaning. Additional photos are then required once those services are completed, especially if the deductions from the security deposit are involved. And then for that date of July 1st, that applies to before move-in. And so that, excuse me, which says that landlords must take and store photographs showing the property's condition prior to the tenant occupancy. And the law itself kind of tightens what can be deducted from the tenant's deposit. So only necessary expenses to restore the property to its original condition are permitted, excluding normal wear and tear. And also things like routine cleaning or cosmetic fixes must be justified with evidence. And tenants now have the right to request an initial inspection before moving out, which gives them a chance to kind of address the potential issues and avoid deductions. Now, landlords have to inform the tenants of this right in writing, and that's within 21 days of the move out, where landlords must provide an itemized breakdown of deductions supported by photo evidence from before, during, and after the tenancy. And the goal again is just to bring more transparency to this process while handling, property conditions and security deposits. Next slide, please. And so before the move-in, you need to conduct a thorough inspection using photos, complete a condition report with detailed notes and time-stamped images, and share that report with your tenants up front to establish clear expectations. During the tenancy, you want to log any maintenance or incidents with photos and written records, and use an organized, centralized system to store those reports and communications. For pre-move out, offer and complete a pre-move out inspection if the tenant requests it, and use side-by-side photo comparisons to show any changes since the move-in, and ultimately share a summary report to help the tenants resolve issues before that final inspection. And for after move out, you want to inspect the property before any repairs or cleaning begin, as I mentioned, and document that condition, and provide a final itemized statement with before and after photos to justify the deductions, and securely store all the reports and documentation for future reference or disputes. And when this is followed consistently, these steps, hopefully will reduce the risk of disagreements, improve transparency, and protect both the landlords and the tenants. And while AB 2801 does promote clarity, it does also require additional operational demands on the landlord. So property managers, landlords may face challenges from their tenants due to incomplete documentation, disputes over property condition, time-intensive inspections, disorganized storage, or lack of transparency. And so we've worked on a mobile application that's designed to help address these issues and streamline and simplify the process of AB 2801, and that's what we call deposit proof. We do have a video here. I'm not sure if the sound's going to play, but I believe you can follow along in the captions. If you could please play that video.
Yeah, there is no sound on it. If you want, we can keep it going or
Sure, it's
send it
only
to
a minute
everyone
long.
afterward. Yeah.
Yeah, just want to show the screenshots of the actual user interface.
Sure.
And by uploading property condition photos.
There it
and
is.
access
There we
with
got
ease
audio.
Whenever.
Tenant, avoid security deposit disputes with deposit proof.
With deposit proof, avoid the hassle and disputes, providing an easy onboarding experience for both landlords and tenants. Enjoy staying compliant without the challenges. Save time by uploading property condition photos and access with ease, whenever, wherever. Deposit proof makes it simple to manage tenancy events, and both parties can enjoy a level of transparency, trust, and security like never before. Deposit proof.
All right, so yeah, as you saw in the video, deposit proof is an all-in-one mobile app. Oh, sorry, I heard some audio there. Deposit proof is an all-in-one mobile app designed to make the compliance process easier and faster while maintaining the required security and transparency. One of the features of the application is that it tracks all your documentation for each unit, and you might be asking what is the documentation. That could include itemized statement of deductions, the tenant notification of right to the initial inspection, any supporting documents for the deduction. Also, it generates statements with all the documentation, You can add comments and descriptions to the photos that you take, photo uploads and acknowledgement notifications. You can report damages into the application. You can also, obviously everything is time stamped as required by law. So for both photos and documentation, and also the unit history is accessible at any time. So all the documentation can be shared among the landlord and the tenant as well. And so I'm going to turn it over to Greg with that said, who will introduce some of the promotions that we're running at the moment around this deposit proof. But if anybody has any questions, please let me know. Thank you again.
Great. Thank you so much, Tolgar. I'll let Greg speak to this offer you all have going on. I also have a poll question pulled up. If you want to learn more about deposit proof, we can send you some more information about it if it sounds like a good fit for you. And Greg, if you want to get on camera and tell us a little bit about this offer that you have going on, we'd love to hear about it.
Yes. So I'm not able to turn on my camera, Alexandra.
Oh, well, it's okay if that's the case. Let me see if I can prompt you to start it. Did that do anything for
Perfect.
you?
There you
There
go.
we go.
All right. So yeah, we have teamed up with Deposit Proof, and we are offering 6 months free of Deposit Proof along with a DrBalcony smart water bottle. Just feel free to email us at info@drbalcony.com, sales@drbalcony.com, or fill out a form at drbalcony.com/contact-us. Include your email, phone number, property address where you may need an inspection, and type webinar in your message. If you type webinar, we know that you are interested in this offer and we'll reach out with that.
Beautiful. Okay. Well, we have plenty of questions. So I know we're at the hour mark, but we're going to go a little over and try to answer as many
No
questions
problem.
as we can. And everyone, we are sending you the email tomorrow. That's tomorrow, Friday, with the slides, the offer in front of you, all of the speakers and their contact information if you want to follow up with them. So take a look at your email tomorrow. It's going to come from AAOA, which is the American Apartment Owners Association. So keep your eyes peeled. Okay, we're going to leave this up on the screen for a little longer. I'm going to start jumping into questions here. We got plenty of balcony questions. Starting with Gina. Now, is the balcony inspection law likely to be extended? If a property is non-compliant after New Year's 2026, who will be issuing those citations, state or local code enforcement? Any thoughts there or predictions on that, Greg?
So I don't believe that it'll be extended again. I really doubt it, just because they did say this was going to be a one-time extension for this last time. And as mentioned, the HOAs didn't get extended. There is more apartments out there than HOAs, so they did give the apartments 1 more year already. It's not going to be extended again. As far as who's going to be policing these inspections, it's going to be your local jurisdiction. So as mentioned, from some cities we've heard that they're going to have insurances require uh, these uh, these reports. So that may be one way. Other cities are saying through the fire inspections, right? So different cities are coming up with their own method and plans right now on how to police these, but that's why they ask that you keep these inspection reports for 2 cycles, so they can backtrack and backdate to the deadline and make sure that you had the inspection done before. So yeah.
So when you say 2 cycles, what do you mean by that?
Yeah, so if you have the inspection done now, right, you have to keep that report in your record for 2 cycles, which would be 12 years for SB721 and 18 years for the SB326. 6 years is 1 cycle, right? So they just want you to keep it in your record for uh, until you have 2 inspections from now. So once again, 18 years for 326. Keep that inspection in your record for 12 years for 721.
Wonderful. So that answers a couple of questions as far as timing goes. Nathan is asking, is a balcony second floor and above?
Yeah, so it has to be 6 feet off the ground. So
6 feet off.
typically that's going to be at least two floors. You could, I guess, have a balcony on a single family, but yeah, has to be over 6 feet off the ground.
Right. So then that might answer Clem's question. Internal metal fire escape over 3 floors is sitting on the floor of the light well, not elevated. Does it need inspection?
So I would always recommend sending us photos, right? I don't want to say no just because I like to look at it, but just from what I heard, if it's a metal fire escape, that typically doesn't have any wood. So I'm gonna say no for that reason. And additionally, if it's on the floor, not 6 feet off the ground, then that's another reason it could be exempt. But if you want to make sure, feel free to send us a photo. Additionally, I will mention San Francisco has their own ordinance for fire escapes. So if you're in San Francisco, make sure that you
Oh,
look into that as well.
good tip there. And that answers Judith's question as well, which she's asking about compromised metal stairs that appear to be exempt. What do you do about those? So, certainly you want to keep your property up to date regardless of whether or not, there's a law telling you to do it. If something is unsafe, you should certainly fix it. So, Greg, any thoughts there on, what do we do about metal railings that also need some upkeep?
Yeah, so most railings that we see are going to be metal. Now, if the stairs themselves are metal and the landing and the walkway is metal, once again, you're 100% right. You should definitely provide some upkeeping for and some maintenance for all of that if you feel like it's a hazard. Now, in regards to these laws, they would be exempt from these laws. The one thing I will say is make sure that the landing is metal as well, because a lot of times we see stairways that are metal and concrete, but then they lead up to a landing that is actually wooden. So or it may be concrete on the top, and then on the bottom there is that stucco with the wood inside. So make sure that there's no wood before you don't get an inspection done.
Ophir is asking if the property is less than 6 years old, is an inspection required?
You'll have a bit of an extension. It's also a case by case scenario where it depends on what year your permits were given to you, your habitability permits were given to you by your local jurisdiction. I believe you have 6 feet, 6 years from that date, from the January 1st of that date. So yeah.
Okay. Linda asking, are HOAs where the homes are owned accountable for balcony inspections?
Yeah. So HOAs are typically always going to be individually owned. And yes, you do need an inspection.
Okay. And what about, John is asking, what about vacant or Ellis or owner occupied properties? Do those need inspections as well?
Yes. Yes.
Okay. Wow. Samantha says here, do we have to complete the inspection if the building is a new building built in 2022, completed 2025? I think we just answered that, right? The other one. So I'll go ahead and dismiss that. What about single family residences? Do those need inspections? Asked Judith.
No. As long as you're not part of an HOA, no. This is only for properties with 3 or more units.
Okay. If there is a problem with a balcony and I restrict access to the balcony, how much time do I have to do the repair? Or can I just take down the balcony and put up a Juliet balcony?
Yeah, so we do have that question quite a lot. So as far as time frame, you would have it would be depending on how severe the defects are. Once again, if they're emergency, you have to apply for any necessary permits within 15 days. Uh, and then if you have a non-emergency, you have 120 days to apply for permits. Once those permits are granted, another 120 days to do the work, right? Now, as far as taking that balcony down and doing the Juliet balcony, yes, that's definitely an option. Just my recommendation would be still go through the city, right? Any sort of modification would require permits from the city. So, yeah.
Okay. And Judith is asking, do you replace wood supports with metal?
That is something that we have done in the past. Uh, uh, we were doing that more a couple of years ago. People were saying, "Hey, well, metal lasts a little longer," but it's honestly the same. If you have a any sort of extra elevated element, whether it's metal or concrete or wood, there's still regular maintenance that has to occur. Uh, but that is an option, yeah.
Great. That's good to know. Vanessa was asking also, you mentioned a method earlier in your presentation. She was referencing that and asking, wouldn't the moisture from the rotted wood be absorbed by the new wood in that method?
No, not typically. N- I wouldn't like to get too much into detail because I'm not an architect myself. But this is a method that's traditionally used, everywhere. And once again, the city is going to have to approve this. So their engineers and our engineers are going to get together and make sure that this is going to be, safe for everyone to use. Now, the way that moisture typically spreads is if more moisture were to enter that balcony. But obviously, we're going to make sure that all cracks are sealed, that all methods of entry for that moisture are going to be gone.
Good. Okay. And also just a quick note, we have a few more questions left, so stick around. And if you did put a question in the chat, I'm not going to be looking there. So this is your opportunity to put your question in the Q&A box and I will answer the few that are left there. Judith was asking, do you re-inspect construction at any point?
So I'm guessing they're asking after they have the inspections
Yeah.
and they have to do the repairs. That's up to your local jurisdiction and depending on your failures. So sometimes the local jurisdiction will ask for the engineer who did your permits and plans to go out there and sign off on the work. Other times the city themselves are going to go out there and sign off on the work. So that'll be determined during the permitting process and once those repairs are done.
Hey, Gina was asking about her courtyard style building from the 1950s. It's a two-story building, donut design with a pool in the middle. So it's 2 stories. I suppose, if they have elevated walkways 6 feet or above with wood, right? That would count.
Yep.
But also she was asking, does the pool need to be inspected for water leak, potentially affecting balcony walkways on raised foundations?
That's not, I don't believe that's part of the ordinance.
I
But
don't
that's a
think
great
so.
question.
I mean, it's probably a good idea if you have
Yeah.
water, there's always a potential for rot, whether it's, elevated or not. Obviously, if it's elevated, that's going to be a lot more of a safety risk, but certainly, you'd want to probably check that out if it's an older build.
Yeah.
Okay. Charisse asked, what are the penalties for the HOAs that have not completed their balcony inspections? So I think you had a chart there at some point, right?
Yeah. So
Mhm.
what we're seeing the most right now is inability to sell your unit, inability to refinance, being red tagged by the city, insurances dropping you. We have heard a lot of insurances dropping HOAs if they are not complying with the law. And then additionally, once again, the law does say $100 to $500 in daily penalties. We haven't seen the $500 be assessed, but we've seen $100 to $200 be assessed.
So if you're in that position, are there ways to expedite and get those clearances faster to satisfy that so that it can be completed during the escrow or purchase transaction?
Definitely. We have a lot of realtors calling us right now that are, the deal's about to fall apart and we do have expedited services. So yeah, just give us a call and typically if you call us, right, we're gonna schedule you about 2 weeks out just to give you time to prepare for your inspection and give everyone ample time, for everything. So if you do need a expedited service, just let us know. We could be out there probably the next day.
Yeah, I would say DrBalcony is going to be the fastest option for you. So that's one of the benefits, right?
Yeah.
Linda is asking here to clarify, does the HOA do the inspection on owned freestanding homes within the development, or do we require the homeowner to do it?
So that's a case by case depending on your agreement with your HOA. So I have seen a lot of HOAs that say, hey, the common areas, walkways, stairways, things like that are our responsibility. The homeowners must take care of their balconies. The one thing I will say is 99% of the time the HOA is going to do it as a whole, and it's going to be 100 times more cost effective that way because we only have to go out there once. Everyone's going to have the same company doing their inspections, which is going to be a lot nicer and more uniform. And Additionally, any sort of permitting process, right? You apply for one permit with the city instead of applying for 50, 60 different permits, right? So definitely my recommendation is do it as an HOA as a whole.
Great. And then another good question, if the balcony access is restricted and no one can go onto the balcony, do I still have to have any balcony problems repaired because no one's walking on the balcony?
So if there's no method of entry, I believe at that point it would likely be a Juliet balcony. It would likely either not have a walking surface or a walking surface that's only maybe a couple of inches. So if that's the case, then you don't need an inspection. But I would just double check that it's a Juliet balcony. I don't think I've ever seen an actual balcony that doesn't have a method of entry. So feel free to give us a call or shoot us an email, and I'd be happy to take a look.
Great. Maybe you can answer this, I'm not sure, but how much is deposit proof?
So deposit proof is free as of right now. So we just launched it. It's completely free as of right now. So something that's really, really, we're really excited for.
Oh, good. Wonderful. Tolgar jumping in here. We got another deposit question here. I thought I saw. Let's see here if I can pull it up. Okay, from Rachel. Are we allowed to get pre-approval for photos from via the lease? I do know we must have permission to take photos inside the unit. Would a lease clause or lease amendment be sufficient?
Yes, the simple answer is yes. From the tenant permission perspective, tenants do have a right to privacy under California law. AB 2801 does require photographic documentation. Landlords do have legal justification, but the best practice is going to be to make consent explicit with your tenants. So you can, add a lease clause or an addendum. That's a strong way to establish like advance consent.
Okay, great. Thanks for chiming in there. There's a couple questions I think I could answer. One is from Mark here. What information can be provided in future webinars on the new air conditioning law passed in Los Angeles County? That is a good point, Mark. That is brand new. It just came out and there are pushes across the country. I actually was interviewed recently in a publication about whether or not landlords should all be required to provide air conditioning for their tenants. Of course, I said, no, but there are ways that we can encourage that and make it safe for our tenants. I know Los Angeles County, though, has gone forward with that. At this time, we are doing California general webinars, but at some point, we'll probably have a Los Angeles specific and then a Bay Area specific webinar where we'll address those individual issues. So good point there, Mark, and good for everyone to know. If you're in Los Angeles County, go ahead and check that new air conditioning law and see if it applies to you. Olga was also asking here if she takes access to the patio out, right? Because either it needs to be repaired or it, is not safe at this point. Can the tenant claim diminished services and argue to pay less rent? And to me, that sounds like an attorney question, which unfortunately Tony has left. He had to run to go to do his attorney things, but certainly that's a great question and we'll be sure to ask him and get back to you on it. I believe that there could be a case for that if that's what was intentionally agreed to by the tenant initially when the lease was formed. So it's a great question and we'll consult with Tony offline on that. A few more balcony related questions here for you, Greg. So I would think Cherie says that there may be issues with HOAs having the reserves to pay for inspections and repairs. Are you finding that a lot?
Yes, we are. Definitely something that we've heard a lot. And we do have different payment plans, right? You can do one payment, you can do one payment at the beginning, one payment at the end. Unfortunately, it is something that, has to be done by the law. And once again, we have the best price guarantee. So you can rest assured you're gonna have the best price with us. Additionally, one thing I will say is we are having a lot of people do their own inspections if your HOA may not have the reserves or the funds to do these inspections. My biggest recommendation is give us a call. We'll do an inspection just for your unit, but that way you're in compliance, right? And you're not facing any potential penalties. So that would be my biggest recommendation.
Yeah. DJ is asking, I have a condo that includes a balcony that has a railing. that does not comply with UBC spacing requirements. So the spacing of those vertical balustrades are too wide. Would that be identified in your report?
So it will be a recommendation. It's not a mandatory repair, because it could possibly be grandfathered in. Now we're always going to say, hey, our recommendation is to update this, but it's not going to be something that causes a failure.
Yes, and then as far as like whether the HOA would be responsible for replacing the balustrades, as you mentioned earlier, that's likely up to the HOA agreement you have,
Yeah.
right? Yeah. Okay. How is the pricing for me determined is the last question. And I think that's a great last question here, because the best way to know is to contact DrBalcony to give you an estimate, right?
Yep, exactly. We do properties from 3 units. I believe the biggest one we've done is nearly 500 units. So give us a call, and we can provide you a free proposal within 24 hours.
Okay, wonderful. Well, for those of you still on the call, you get a gold star for sticking around this long and listening to all the questions. You clearly want to be informed and educated on this. And it's so important, I think, especially in California, to stay up to date with all the laws. We do these pretty regularly. DrBalcony does their balcony webinars every week. So we certainly will be seeing you guys, I'm sure, more often as the laws develop. And we're so happy to have experts like you on the call. And again, everyone is going to receive the full presentation and the recording, the slides, the speaker's contact info, the special offer from DrBalcony. And we'll hope to see you in the next webinar next week. We'll send you an invite for that as well. Check your emails tomorrow, please. It's coming from aaoa.com. And again, thank you so much. And feel free to share. Yes, Michelle, anyone who wants to share is welcome to share. We love sharing. And that's why we do this, because more people need to be aware of what the heck is going on in California.
Yep.
So thank you guys. Appreciate it. And I hope you all have a wonderful day.
Thank you, Alexandra.
Bye.